One of the questions I frequently get from viewers is there a special way that lawyers have to argue points of law in front of a court of law? And the answer is, yeah, there is a way that we do that, and it's actually pretty simple and easy to learn. I'll have a little bit more on that in just a moment. When a legal question is presented in a case, lawyers write a brief or a motion or a memorandum in support, and most of us follow a pretty generic formula. Some of us vary it a little bit from time to time just to keep things real, but the formula itself is pretty simple. The first thing is the issue. Now, the issue is just the question that the court needs to answer. If there's a legal question in a case, for example, whether something should be admitted into evidence, for example, that's the issue. In this example, we're going to use a similar issue. We're going to say, what is an executory contract? And we're going to do that because I've just finished doing some briefing on that issue and it's fresh in my mind. Nothing special there, just something that, again, is easy for me to talk about at this moment. The second thing that lawyers do when they brief something is they find the rule that applies. Now, that's not always as easy as it seems because many times the rule varies with the facts, and sometimes it varies with the statute, and sometimes there's questions about which statute controls or which statute applies. Each one of those can be separate issues in a brief. But for this case, we're going to talk about the issue being what is an executory contract. The rule is where you have two parties to a contract, Party A and Party B. Party A makes an agreement to do something. Party B makes an agreement to do something. And those two promises constitute an executory contract. The promises at the beginning of the contract are not fulfilled. So I promise to pay you $50 if you promise to fix my watch. That's an executory contract. Unfortunately, or fortunately, depending on which side of the case you're on, once a person performs their portion of the contract, it is no longer executory. So, for example, if Mr. Smith says to Mr. Jones, I want you to fix my car, Mr. Jones says, I'll do it for $500. Mr. Smith says, I'll pay you $500 to fix my car. At that time, you have an executory contract. If Mr. Jones then thereafter goes and fixes the car, he has fully performed his duties under the contract, and the contract ceases to be executory at that point. It's still a contract, but it's not executory. And there are certain areas of the law where that distinction is important, bankruptcy being one of them. After you have the rule, in other words, in this case, what makes an executory contract executory, unperformed duties on both sides, then you have a section of analysis. And the analysis section simply applies the facts to the rule of law. And if we're dealing with Mr. Smith and Mr. Jones, when Mr. Jones finished his performance of that contract by fixing the car, the contract was no longer executory. Now, I'll give you an example of why that would matter. If Mr. Smith filed bankruptcy after making that contract with Mr. Jones, his trustee, his United States trustee in his bankruptcy would have the choice of either assuming that contract or honoring it, or avoiding it or rejecting it. And in order to avoid or reject a contract or assume it, it has to be executory. And the reason is because if it's already been performed, then what exists is not a contract. It's just a debt that's owed by the estate. So that's a good example of why something like an executory contract might matter. But you can see that you apply the facts to the rule of law, and that gives you your analysis section. And then the final part is just the conclusion. Therefore, this is not an executory contract. Or therefore, this is an executory contract, depending on how you wish to argue the question. Now, that breaks down into 4 things: issue, rule, analysis, and conclusion. Or, very simply, what lawyers are taught in law school, IRAC, I-R-A-C. And that is pretty much how every single point of law in a brief or in a motion is written and argued. If you found this interesting or helpful, I hope that you will take a moment to smash that like button and click on the subscribe bell and subscribe icon and subscribe to the channel. We post videos here fairly frequently, and we try to answer as many questions as we possibly can on subjects that people have, questions that people have about the law. If you've enjoyed this, I'd appreciate it if you'd leave a like and a subscribe and a comment in the comment section below, because it helps feed the algorithm. And remember, smashing that like button doesn't cost you a thing, and it makes you feel warm all over. Have a great day, guys, and we'll catch you next time.